Good afternoon. I'm Linda McLean. It's my honor and pleasure, on behalf of the Dean of the Boston University School of Law, Maureen O'Rourke, and on behalf of the Faculty Workshops Committee, to welcome all of you to the Law School's annual Distinguished Lecture, and to introduce today's lecturer, Professor William Eskridge Jr., John Garver Professor of Jurisprudence at Yale Law School. The annual Distinguished Lecture is a highlight of our academic year. This year, we're especially fortunate not only to have a preeminent legal scholar address us, but also to have him address us on a topic that could not be more timely. And in the publicity for this lecture, the title was The Long Road to Marriage Equality, 1970 to 2012 and Beyond, and the slightly revised title today is Beyond Backlash, How Constitutional Litigation Has Advanced Marriage Equality. And the very timeliness of this topic explains why C-SPAN is taping this lecture and will broadcast it to a wide audience. And let me ask you now, if you haven't already, to turn off all pagers, cell phones, and mobile devices before we begin. Don't just put them on vibrate, please. Another note, during the Q&A portion of this event, of which we hope to have a substantial period, please stand and wait until a volunteer hands you a microphone before you begin to speak. So those are my technical details. Okay, back to the introduction. I know that Professor Eskridge has had the happy task of updating his PowerPoint slides after the historic outcomes on November 6th in Maryland, Maine, and Washington, where voters for the first time approved ballot initiatives in favor of allowing same-sex couples to marry, and voters in Minnesota rejected a constitutional amendment that would enshrine Minnesota's ban on same-sex marriage in its state constitution. We're very excited about this opportunity to hear Professor Eskridge put these most recent developments in a historical perspective, and the BU Law Review is also very grateful to have the opportunity to publish this lecture. As you'll see from the publicity about this lecture, Professor Eskridge is a distinguished scholar in several fields. He could easily be addressing us today about statutory interpretation, about legislation. He's also an architect of the field of law and sexual orientation, or legal treatment of sexual and gender minorities. Today, he's addressing us on a topic to which he's devoted enormous scholarly effort, marriage equality. His analysis has influenced litigators, judges, lawmakers, as well as scholars and law students, and I'll just briefly mention three features of his work that have been broadly influential and from which I have personally benefited in my own work. His historical work. Professor Eskridge carefully unearthed the history of same-sex unions, taking on the claim that same-sex marriage is simply unheard of, and his work on the history of the struggle for same-sex marriage in this country took on the claim that for the most part, the gay rights movement was simply not interested in marriage. Second, he has advanced normative arguments in favor of same-sex marriage, why it is good not only for same-sex couples, but also for society. And third, his comparative work on the legal treatment of same-sex couples has shaped the debate. His book with Darren Spadale, Gay Marriage for Better or for Worse, What We Learned from the Evidence, with the emphasis on evidence. He wrote about gay marriage in Scandinavia and took on claims by conservatives that when countries legalize marriage, a cascade of disasters befalls the institution of marriage and the family. His comparative work also introduced to American audiences the theory of small changes, which is that countries typically follow a pattern of incremental steps along the pathway to full equality and liberty for gay men and lesbians. This has provided a very helpful context for the civil unions versus marriage issue. These are just three of his enormous contributions. Without further ado, it's my great pleasure to introduce you to our distinguished lecturer, William Eskridge Jr.
Well, I appreciate the invitation, and I very much appreciate that wonderful and substantive introduction by Professor McLean, whose own book on ordered liberty is coming out, I think, with her different sex spouse next week, and which is actually going to address some of the issues that I'm going to talk about today. So it's very appropriate that I'm talking to you about this issue today, basically a week after the election. And then I'm doing this in Boston. So you see my first slide is there's nothing new about same-sex marriages. Boston marriage is the name taken from the famous James novel, The Bostonians, had a same-sex lesbian, not lesbian, but female couple patterned on his own sister Alice James and her longtime companion. Now we've come a long way since the James brothers and sisters to November 6th. And this is certainly an area that is one of the most exciting areas of public law today. So maybe it's very appropriate that the Law Review is going to publish this, and I'm going to advance some new arguments in this lecture. This is one of the most dramatic of our public law and constitutional issues. It's more dramatic and I think more fun even than watching television. Though which television show you're watching depends utterly on where you're coming from. So for example, I think this is an analog to Modern Family. I think same-sex marriage is delightful. It's part of the great Rainbow Coalition of television and America, and I think that it has a future. In contrast, however, Gerald Rosenberg, whose ideas I'm going to address as I move along the long road that Linda promised you, Gerald Rosenberg has argued in a series of articles and in the revision of his famous book, Hollow Hope, that same-sex marriage is not so much like Modern Family as it is like revenge. Now, I can see there are not many TV watchers in this audience, though there might be in the C-SPAN audience. Revenge is a show that is not about happy families, it's about sick families and the revenge that happens when things are stirred up. Okay? So the Rosenberg story is that same-sex marriage litigation has led not on the whole to advances for lesbian and gay couples, but instead to revenge and backlash. Now there's a third story that might be told, and it's not well represented either in this lecture, and that is a story by the many sincere traditionalists, a lot of them religiously motivated, who think that same-sex marriage is not like Modern Family, is not like revenge, but is instead like Homeland. The very famous Showtime series about a Trojan horse, former prisoner of war, who was burrowing into the American body politic and who will ultimately destroy America. And so those are the three television stories. They're all saturated with drama. They're all very exciting. Let me start at the beginning of the litigation saga, because there were not Boston marriage litigations. Instead, the litigation that I want to talk about in the long road begins after the Stonewall Riots. The Stonewall Riots in New York in 1969 represented the first time in recent history that lesbian and gay people literally fought back against the long-standing police oppression. There were several evenings of riots. They made the New York Times, albeit I think only on page 15, and they galvanized literally tens of thousands of lesbians and gay men to come out of their closets where they had been residing and to announce themselves as open homosexuals. This was the first time in American history large numbers of lesbians, gay men, bisexuals, and transgendered people had come out of the closet publicly. Some of them came out of the closet as couples, as people who were committed to one another in a long-standing union. Sometimes they were even raising children together. And some of them had the asperity to argue that not only are we openly gay or lesbian, and not only do I have a committed same-sex partner whom I want to die with and raise children with, but I also think that we have the right of the state to recognize our unions as civil marriages, the same as different sex couples. Now, interestingly enough, at the very point when a fair number of same-sex couples started thinking this way, there was a Supreme Court decision, a landmark Supreme Court decision that I'm sure you are familiar with, Loving versus Virginia. The Warren Court had handed it down in 1967, and it had struck down the remaining laws, mostly in the South, that barred marriages by different race couples. The Supreme Court says If you bar a race by a different race couple, that is race discrimination. It is suspect as a classification, and we're going to strike it down because we think there is no compelling state justification that Virginia and these other states had advanced. Supreme Court also in Loving versus Virginia ruled that the discrimination by the state violated the couple's fundamental right to marry. And many lesbian and gay couples in the 1970s, all the way through to today, have taken that language in Loving and subsequent decisions to assert that lesbian and gay couples, like the different race couples in Loving versus Virginia, have a fundamental right to marry, and the state ought to have a higher burden of justification before it denies those couples of that fundamental right. Subsequently, in the debate in the United States, the early 70s, over the Equal Rights Amendment, many of the opponents of the Equal Rights Amendment say if you add this to the Constitution, banning effectively sex discrimination, then this will lead immediately to same-sex marriage based upon a Loving analogy. Not the fundamental right to marry, prong of Loving, but the discrimination prong. Because the opponents suggested, I think quite logically, that if you have a woman and a woman seeking a marriage license, say I would like a license for my female partner, and the licensocracy denies it because her partner is not a man, that is literally a discrimination because of the sex of the partner. It's a sex discrimination. And some people had the asperity to argue in the early 1970s that same-sex marriage should be required by either the federal ERA, which never passed, or the many state ERAs that did pass in the 1970s. So like other groups, African Americans, Asian Americans, and women themselves, lesbians and gay men in the early 1970s began to see themselves as a minority, a cohesive minority that should not be treated unfairly, and for whom discrimination based upon sexual orientation was just as irrational from a public point of view as race and sex discrimination. The first lawsuit, it might surprise you to know, serious constitutional lawsuit with the ACLU involved, was 40 years ago. It was the Baker versus State lawsuit. This is the same-sex couple, Baker and McConnell. They brought the lawsuit in Minnesota, which just the other day rejected an effort to ban gay marriage by a constitutional amendment in that state. Minnesota in the early 1970s, however, was not so receptive to same-sex marriage. When their case got to the Minnesota Supreme Court, Baker and McConnell got to watch as at least one of the Minnesota Supreme Court justices literally turned his back on their arguments. Sitting in his chair, he turned his chair around as the ACLU attorney was making the arguments for marriage equality in Minnesota. Not surprisingly, not a single justice asked a question. They wrote a very short opinion denying the right. The ACLU lawyer took it to the Supreme Court, which dismissed the appeal for lack of a substantial federal question. I've written earlier books detailing the history of a number of other lawsuits in the period of the 70s and the 1980s. And they were all as unsuccessful as the Baker lawsuit was in Minnesota. And I suggest in the slide some reasons why these lawsuits were uniformly unsuccessful in that period. There, of course, are cultural reasons, and I believe these are probably the dominant ones. Arguments for gay marriage seemed off the wall. Marriage, as a matter of the dictionary as well as common parlance, was strongly associated with procreative unions between one woman and one man. There was also the widespread perception, even among liberals, that gay people, or as they were called in those days, homosexuals, were intrinsically anti-family, that homosexual unions were sterile unions, non-procreative unions, that could never be the basis for the normatively elevated institution we call marriage. And then when you get to the 1980s, the AIDS epidemic created even further antimony, if any there need be, against lesbian and gay claims for equality. And the fear of AIDS and Trojan horses, i.e. gay men bearing the AIDS virus, created a climate of overwhelming hostility in most quarters to these claims. Notwithstanding that reason, which I think is the main reason, I think the Supreme Court in this period would not have been receptive to these claims. And to the extent the Supreme Court sets the mood for many of these claims, I think that would have been important. The Nixon and Reagan Supreme Courts of the 1970s and the 1980s were a very conservative collection of justices. Most of the justices themselves openly harbored anti-gay prejudices, and almost all of the justices were reluctant and some utterly unwilling to expand the race precedents, like Loving, to protect other minorities. And then finally, and maybe not least importantly, during the period that we're talking about, most states continued to have laws that made it a crime, usually a felony, to commit consensual sodomy with an adult partner in a private space. And so there was a further analytical conundrum that how could you recognize gay marriage, certainly as a matter of constitutional litigation, if not as a matter of statute, if the underlying consummating sexual conduct is a felony in your jurisdiction? And that is a logical as well as a cultural conundrum. So there's my map. Here is the map of the United States in 1999, in fact, that the state of gay unions throughout the 20th century. So that's not a, I don't know if you need it again, if you want to write down some of those states, but there is the map. The 1990s is a major turning point, though exactly as Gerald Rosenberg and other scholars have argued, it is a turning point with many different turns in that decade. But the 1990s sees a revival of the gay marriage litigation movement. And I was actually the attorney in the first case after Denmark in 1989 recognized same-sex registered partnerships. The Danish statute was very important because it specifically motivated some of these earlier litigants. My clients in the District of Columbia included one lawyer who was a graduate of the Georgetown University Law Center, and they read about the Danish statute and said, why can't we do this in the United States? And so they took it to the ACLU, got spurned, they took it to Lambda, got yelled at, they took it to their legislators, had the door slammed in their faces, and they ultimately took it to the Georgetown University Law Center, a distinguished Catholic institution, and got themselves a lawyer. So we brought a constitutional litigation. It's very easy to bring constitutional litigation in the United States, and we brought it, and there was a lawsuit also brought in Hawaii. And we thought, yes, why, if not Denmark, a la Hamlet, then the United States maybe ought to be thinking about this, and the arguments, at least analytically, seemed so powerful to us. Moreover, American public opinion in this precise period, the early 1990s, the post-Denmark statute period, turned decisively away from the public opinion negativity of the 70s and 80s. Now, public opinion certainly did not turn in the 1990s toward gay is good, which is the longtime motto of our movement, and instead it turned to gay is barely tolerable. Now, from our point of view, that was a huge step forward. I am not kidding. When you are a minority that has been despised and persecuted and electroshocked throughout the 50s, 60s, and 70s, and in the 80s, you are the bearer of a dreaded disease that America hates and they hate you as well, to move from being a despised and anti-American minority to a barely tolerable one is the best news in your life. And that's what happened to gays and lesbians in the early 1990s for various reasons. And then further in the 1990s, state Supreme Courts revived a strong interest in state constitutionalism to protect the rights of minorities that the Berger and later the Rehnquist courts were not willing to do. And state constitutionalism went with a vengeance after sodomy laws. In the wake of Bowers and Hardwick, the snarky 1986 Supreme Court decision upholding consensual sodomy laws in the state of Georgia, where you could receive 20 years in prison for sodomy and a mandatory minimum sentence, by the way, of 1 year in prison for consensual activity. The Supreme Court upholds that. But in the 1990s, one state Supreme Court after another, and some in unlikely places like Georgia and Arkansas and Tennessee, as well as other states, strike down the sodomy laws under their state constitutions rather than the federal one. And of course, that culminates ultimately in Lawrence versus Texas in 2003. So in this climate, it seemed like the time was ripe. Now, in the DC case, where I represented the couple, we lost 2-1. In retrospect, maybe that was a blessing for the movement. Because in the one state where we did win this litigation in the 1990s, Hawaii, the Hawaii Supreme Court in Bayer and Lewin in 1993 tentatively made a feint in the direction of marriage equality by ruling that the exclusion of lesbian and gay couples, a la Loving, was a sex discrimination which under the Hawaii Constitution is subject to strict scrutiny. They remanded for trial to see if the government could meet its burden of strict scrutiny. But in 1993 and following, as many scholars have documented, there was a tremendous backlash against the Hawaii Supreme Court's ruling that same-sex marriage might be on the horizon in that state located thousands of miles away from all the other states. After the Bayer and Lewin ruling, there was a wave of state non-recognition laws between 1995 and 2004, and even continuing till today, specifically seeking either a constitutional amendment or a statute saying not only do we reaffirm that our state, Minnesota or whatnot, will not recognize same-sex marriages, we won't recognize same-sex marriages from any other state because they might infect the body politic with this disease. Even in Hawaii, which is a very tolerant state, the voters voted 60% in 1998 to amend their state constitution to allow the legislature to limit marriage to one man, one woman. And in the biggest example of backlash, the National Republican Party in 1996 seized upon this as a possible wedge issue to take away Catholic and Southern Baptist voters from the wily Democrats and pushed the Defense of Marriage Act, which proposed to ratify all of the state non-recognition laws and also to permanently codify in the federal statute books the proposition that the 1,100 plus federal statutes and regulations that pertain to marriage and spousehood will never pertain to same-sex couples. Even if all 50 states ultimately recognize same-sex marriages, the federal government never would as long as DOMA was on the books. And the Democrats, under President Clinton, not only did not resist the statute, but fulsomely joined in and supported the statute, leaving you with the spectacle in 1996 of Speaker Gingrich of the House, Majority Leader Dole of the Senate, and President Clinton of the entire United States, the leaders of their respective parties, the latter two, the candidates for president in 1996, and perhaps most ironically, the three highest ranking adulterers in the United States, sponsoring an effort to protect marriage against lesbian couples raising children in committed relationships, only in America. So the 90s was not a big era for advance in many respects. But Bayer was nonetheless a breakthrough because it was a demonstration that this was an important issue, and it also inspired other lawsuits, though lawsuits that were more politically savvy. I do think a big breakthrough was in our neighboring state of Vermont, in Baker v. State, where grassroots movement led by Beth Robinson, now at the Vermont Supreme Court, and Susan Murray, persuaded the Vermont Supreme Court to strike down the exclusion of gays and lesbians from all of the benefits and rights of marriage. But interestingly, the Vermont Supreme Court left it to the legislature to provide a remedy. Did not order same-sex marriage, left it to the legislature. And in many ways, I think that was a brilliant move because in 2000, the Vermont legislature, in a bipartisan effort, though dominated more by Democrats, established a civil unions law which survived the inevitable political backlash at the polls in the 2000 election. And so you had a beachhead in the state of Vermont for something like the Danish model of 1989, a statute which extended to lesbian and gay couples every one of the legal rights, legal benefits, and legal duties of marriage, albeit under this other institution called civil unions. Not much notice, but also quite important, California in 2003, just a few years later, did the same thing in its state by expanding its domestic partnership statute. Even more, the Netherlands in 2001, right after Baker v. State, recognized through a parliamentary statute same-sex marriages, followed by tiny Belgium, and then followed very importantly by the state in which I am now standing, Massachusetts, responding to gay and lesbian advocates and defenders, the Boston-based litigation group, and a very intelligent political campaign. The Massachusetts Supreme Judicial Court, narrowly, by 4-3, I think, ruled that marriage exclusion of same-sex couples violates the state constitution. They gave the legislature several months to implement this, reaffirmed their ruling in 2004 when the legislature queried would civil unions meet the mandate, and the answer was no. So in May of 2004, for the first time in the United States, officials in Massachusetts started handing out marriage licenses to same-sex couples, and marriage licenses that were respected. There had been marriage licenses handed out before, but they had been nullified in previous campaigns. As Gerald Rosenberg has argued, there was indeed a backlash against the Goodridge decision here in Massachusetts. In my view, however, somewhat contrary to Rosenberg, this backlash was much less pronounced than the backlash after Bayer versus Lewin. In the state of Massachusetts, for example, Governor Romney's persistent campaign to amend the state constitution to override Goodridge was rebuffed at every turn by the legislature, so it never actually reached the ballot. President George W. Bush's campaign for the country to adopt a federal marriage amendment did not get through even the Senate. In a vote to cut off debate in the Senate, a cloture vote, the supporters of Bush and the federal marriage amendment could not even secure a majority. Now, to be sure, there were, again, a proliferation of state constitutional amendments, mostly by initiative, that barred marriage equality and even sometimes civil union claims in 2004 to the 2008 election. But nonetheless, in 2004, we actually start to get color in the map that I gave you before. Red is Massachusetts. It stands alone in this period as recognizing full marriage equality, but you had substantial equality in Vermont and California, and a modicum of equality even in Hawaii that had a reciprocal beneficiaries law. So the map is beginning to fill in. After Goodridge, and Goodridge is the big breakthrough, the marriage equality movement picked up steam after that breakthrough. And here is the basic strategy, in my opinion, that movement has followed. It has been a normative movement in each state, and it has shown the following progression in each state, and each state has moved at a different pace than the others. In some states, you still had, in the 1990s and the early part of the new millennium, to confront the idea that gay people are outlaws and violators of sodomy laws. Lawrence sweeps this away from all 50 states, most of which had already repealed these laws or nullified them by 2003. More important innovation during the period we're talking about is the adoption of anti-discrimination laws. Massachusetts was one of the pioneers here. A number of other states, most states have now followed Massachusetts in some form, prohibiting discrimination based on sexual orientation. In state employment, most of the state laws also prohibit discrimination in private employment, many of them also in public accommodations and other venues. Romer and Evans was a famous Supreme Court decision that struck down an effort by a Colorado voter initiative to sweep away and permanently prohibit these kind of anti-discrimination rules at the state or even the municipal level. And many religions, this is a little appreciated point, but many religions, including the Roman Catholic faith, aggressively and actively denounce discrimination based upon sexual orientation, not an unemployment point. And then finally, there has been a rise in many jurisdictions of the gay is good idea. And in these jurisdictions where a significant number of the populace believes that not only is gay not malignant or worthy of being outlawed or even just barely tolerable, but gay is actually fine and good, and I don't mind if my daughter marries one. In these jurisdictions, we have seen the biggest audience for marriage equality, where gay marriages have been recognized, where religions, in many cases, have celebrated lesbian and gay unions and marriages, and where, as we had seen with race, a politics of presence actually changes social attitudes in a direction toward tolerance and even acceptance. At the same time that Massachusetts is acting in this very important way in the United States, our neighbor to the north in Canada is going through exactly the same kind of cycle of litigation, pushback, and at least in Canada's case, legislation as well. A landmark Canadian Supreme Court decision in '99 prohibits family-based discrimination against lesbian and gay couples in terms of rights. That provokes marriage equality lawsuits at the provincial level and provincial decisions supporting marriage equality, and Parliament in 2005, just shortly after Goodridge, adopts a marriage equality statute. The sky did not fall on Canada, and that statute has survived under conservative governments as well as liberal governments. We've seen marriage equality in Spain, South Africa, various parts of Scandinavia, more than a dozen countries in the rest of the world. And in Europe, if you don't have marriage equality, you're likely to have registered partnerships or something like that in the European countries that have not gone all the way. Here's a list of the situation in the United States after Goodridge. Maybe more useful is the map, and the map, exactly as Professor McLean suggested, has been updated to take account of last Tuesday. So I've filled in some more red. I've not had to decolor anything based upon the results last Tuesday. And you see the pattern. The pattern is very significant. It's a lot like Europe, except New England, that's us, playing the role of Scandinavia. And we're even kind of similar. We're very cold. We're clumped together. There are not that many people. We're very cultured. We're like splendid. It's very splendid. And it is adopting same-sex marriage almost as a clump. The only holdout so far is tiny Rhode Island, which has civil unions, and I'm sure that they will rectify that very soon. So you see there is a certain degree of clumping. In the book that Darren Spadali and I wrote in 2006, we laid out, here are the data based upon legal changes that various states have made, and we provided a map. And one color in the map was states that would adopt marriage recognition in the next 10 years. And another color was battleground states. Another color was no-way states. And the states that we thought in 2006 would move in this direction are exactly the states that are on this map. The colored maps are exactly the same. It's been very predictable. But unfortunately, it's also very predictable that the third group of states I described are not going to adopt marriage equality anytime soon. And then we'll have battleground states like Pennsylvania and Ohio, Michigan, exactly the kind of states that you would expect. So that's where we are today. And Professor McLean suggested it's a long road. Obviously, most of the country is still not colored in, and so there is a long way to go. Though I suspect that most of you in the audience, and this is certainly my point of view, believe that it is now inevitable, that there is no turning back on marriage equality for the very simple reason that the lesbian and gay couples who have gotten married or who want to get married, many of them raising children, are actually good couples. They're fine. They want to be married for the same reason that straight couples do. They want to have children for the same reason that different sex couples do. Their families interact with other families the same way, the same. And it's actually good for America. It is not a big deal. It is indeed a good deal. And young people realize this, and old people who do not are dying. Now that's the long-term prognosis. this is why you see, for example, one of the witnesses in the Prop 8 case. There were only two witnesses for the supporters of Proposition 8, the California Initiative Against Same-Sex Marriage. One of the witnesses is already recanted, says, well, I'm now in favor of same-sex marriage. And you ask him why. Was it a road to Damascus experience like Saul of Tarsus had? He said, no, it just seems inevitable to me now, and it does not seem to me to be a great calamity. And I think that's a widening perspective. But it's also a widening perspective, particularly among young people, that this is the great civil rights cause of your generation, and that this is something that is good to be on the right side of, and not to be on the side that looks like George Wallace. But nonetheless, this is still a very intense issue, and many very decent people do disagree with one another on this issue. So here's how it's playing out. We are still going to see state popular initiatives. Many states have already passed them. Most states now have constitutional amendments barring same-sex marriage. Those would have to be revoked either by a new voter initiative, like what we saw in the state of Maine, or by some kind of federal constitutional litigation. Obviously, California is the primary example of that. California in 2008, I talk about this at greater length in my article, sees its state Supreme Court under the state constitution require marriage equality in the state of California, and something like 18,000 or so marriage licenses were issued between July of 2008 and November of 2008, the latter date being when Proposition 8 was voted in by the people of the state of California to amend the state constitution to override the court. The court later interpreted Proposition 8 not to nullify those 18,000 marriage licenses that had already been given out. Now, there would be two ways of responding to Proposition 8, aside from acquiescence, which is not a possibility. The more logical one, the smart one, would be to go back to the voters after a better educational campaign, the kind of educational campaign that the voters just had in the state of Maine and responded fairly warmly to. In my opinion, we had a lost opportunity in 2008 in California. Based upon expert opinion, the campaign against Prop 8 was mainly run in glittering generalities. Do you believe in equality? Well, vote with us. I think that's a very poor idea to run a political campaign. I think a better idea would be to suggest we have lesbian and gay couples, many of them raising children, here in the state of California. They want to get married. Here in their own voices is why they want to get married. Here's what it means to them. Here's what it means to their parents, the grandparents of their children. Here's what it means to their children. Here's what it means to their neighbors. Here's what it means to their ministers, to their rabbis, to their priests. Some of whom don't support same-sex marriage, but do support these couples who are serious couples seeking recognition of their serious relationships, particularly relationships that are long-term and raising children. And that's the way they should have run it in 2008. I think that's the way they did run it in Maine in 2012. And we would have, in my opinion, without doubt, won such an initiative in 2012 in the state of California. Yet you might have noticed, if you're an astute watcher of the election results, there was no initiative on the California ballot along these lines in 2012. And the reason was a federal lawsuit which was brought in the wake of Proposition 8 to challenge the discrimination as a violation of the Equal Protection Clause. That suit is now before the U.S. Supreme Court, which is considering whether or not to grant review, and they either will or they will not. If they don't grant review, which I think is more likely, they'll either not grant review or they'll vacate and remand for the Ninth Circuit to do some more thinking. Ninth Circuit will then reaffirm and see where we are. At some point in the future, I think we will have same-sex marriage in California. But I think it would have been a simpler process and a more legitimate process if we had done it through some kind of voter initiative. Now, at the same time, we're now seeing the federalization of litigation on marriage equality. We're also seeing parallel federal constitutional litigation attacking DOMA. Remember, that's President Clinton, Senator Dole, Speaker Gingrich. That's the statute that they delivered us in 1996. So there have been a number of challenges to DOMA, and DOMA is indeed imploding. Federal judges, including dozens, literally dozens of bankruptcy judges, are ruling that DOMA is unconstitutional as applied to the statutes that they are implementing. Attorney General Eric Holder says we're not going to defend DOMA's constitutionality anymore at the Justice Department, though the administration is still enforcing DOMA until it's disposed of. And then there have been decisions now in the First Circuit and the Second Circuit, First Circuit, our circuit, chock full of BU graduates. I believe 2 of the 3 panel members are graduates of this law school, if I am correctly informed, have struck down the Defense of Marriage Act. And I think the First Circuit opinion will be a very solid foundation for a Supreme Court ruling, because the Supreme Court will certainly take review on this and will issue some kind of result probably next June. The final question, of course, is the Perry question, the Proposition 8 question, and that is, does the U.S. Constitution require states to recognize same-sex marriages? Now, as Professor McLean suggested, I argued in 1996, right on the eve of DOMA, as it turned out, that the Constitution, as a matter of principle, does prohibit such discrimination. So the question, I think, is not, does the Constitution prohibit it? Because I think that is the right answer. And I believe that is the answer that we will have to reach as a society at some point. The real question is, do we want the U.S. Supreme Court to reach that result in 2013 by taking review in Perry and ruling as broadly as Judge Vaughn Walker ruled at the district court level? Or do we want the Supreme Court to rule more narrowly, as the Ninth Circuit did, and I supported that with an amicus brief? Or perhaps the best result is for the Supreme Court simply to deny review or to send it back and have the Ninth Circuit reaffirm it and same-sex marriage licenses start issuing in California again. And the reason I think that is that I think this is an issue whose outcome is inevitable, but it is not inevitable that that answer will be delivered in 2013. And that's where we get to the final portion of my talk, and I'll wind up. It's going to be a major focus of the Law Review article that I hope the Law Review will publish. And that is, I think with McLean's gun to their head, that also might be one of these things that is more certain than not. Here's another way of looking at the long road I've just described. And what I try to do in the article is provide, I think for the first time, an actual theoretical basis for what political scientists have been calling the politics of backlash. And here's the way I see it. When you think about same-sex marriage or equality of marriage debate in the United States, there are 2 different kinds of debates that we have been engaged in. One is a policy debate. Is same-sex marriage a good idea? Is there a need for it? Would it have bad consequences? Would it cost money? That kind of debate. That is a relevant debate. Serious thought should be done on that debate. But there's another debate that has been going on in tandem and has dominated the policy debate, and that's what I would call a small c constitutional debate. It's a debate about identity. It's a constitutive kind of debate. So it's constitutional in the very literal sense, not just constitutive of our society, but constitutive of people's identities. And so long as it has been for most of my life, as the debate involves intense identity politics on both sides. Because one thing we should not delude ourselves about, if lesbian and gay people consider this identity politics on our side, as I do, it is also identity politics on the other side. It is not an example of just simple raving, drooling bigots who want to deny gay people their rights. The typical opponent of marriage equality is someone who is a matter of her own identity as a person, as a traditionalist, as a religious person often, as a member of a family, as a member of a community, believes that it does not behoove her family, her community, her polity to depart from the traditional definition of marriage as this procreative union between one woman and one child. And if you're a liberal and you find that hard to swallow, think about this. Many liberals, including many of you in this room, do not favor the death penalty. And you're not just opposed to it, you're opposed to being a member of a society that has a death penalty, even though you will not be subjected to it. I guarantee it, at least most of you. And the reason you oppose it is not a policy reason, though I'm sure you could give me lots of policy arguments. The reason you oppose it is a constitutional reason, a small c constitutional reason. You don't care about the Eighth Amendment. You care about not being a member of a polity which puts people to death, particularly when putting people to death is racially biased, as it traditionally has been in this country. So that's why Professor Rosenberg is actually onto something. That this is an issue that has divided the country intensely, fairly evenly, even today, and it divides us as a matter of identity. Now, the way I see it, I think there has been an evolution of what has been generally called the politics of backlash. And here's the way I see the evolution. For most of the period that I am talking about, from Baker to Baker, Minnesota Baker to Vermont Baker, the politics of backlash has overwhelmingly dominated normal politics. That marriage equality for years was simply ignored. Then when it sprung onto the public agenda and was actually on the front page of the New York Times, it triggered local as well as massive national backlash. Traditional family values people were alarmed, and the GOP was able to use it as a very effective wedge issue, though not effectively enough given the wiliness and unscrupulousness of the sitting president. So backlash dominated, and any effort to disturb the status quo was going to provoke an overwhelming response. Now, the second period, I think, really begins in earnest with the Vermont Civil Unions debate, which was a debate saturated with backlash, but also saturated with people who thoughtfully actually did consider the policy issues and actually changed their minds even about the backlash issues. I think we've seen that with Goodridge here in this state. I think we've seen that with the marriage cases in California. And then there are a number of other states, either through litigation or New York through legislation, that have recognized marriage equality. Again, there has been backlash. Again, people's identities have been affronted. But the backlash has been very much less than it was after Bayer and Lewin. And the issue is now balanced, I think, between backlash and normal politics. And here are data taken from Nate Silver, the 538 guy, on what the numbers look like. These are not numbers of a backlash politics. That early on, very little support for marriage equality. In the wake of Goodridge, however, the numbers have steadily gone up. And the variable, in my opinion, is Goodridge. The Goodridge triggered a short-term response that was both positive and negative. But I think the consequences of Goodridge, which is, I believe, since 2004, there have been more than 10,000 marriage licenses handed out here in the state of Massachusetts. There have been other marriage licenses in other states. There is now a choreography of equality that we had not seen in the United States before Goodridge. And here's the title of what I want to publish with the Law Review, I think after 2009, and very much illustrated this year, we're moving beyond backlash. And I think we have to thank for this, not just Ellen DeGeneres, which is the one we usually thank, as we should, and not just the LGBT lawyers, whom we also should thank, like Mary Bonato here in Boston, who is a hero and a brilliant and fabulous litigator, not unfortunately a graduate of this law school, but she's great nonetheless. But we also should extend a vote of thanks to Governor Cuomo of New York and President Obama, and even his Gabby vice president, for coming out of the closet as openly straight mainstream politicians who are in favor of marriage equality in very measured, very reasonable tones. And then we saw the results in the 2012 election. This did not cost President Obama the election. It probably helped him. President Obama had a good, healthy margin of victory in the popular vote. His margin among LGBT voters was larger than his margin of victory. Now, you could also say that's true about female voters, Latino voters, and African American voters. There are lots of groups you could say it about, but it is also true of lesbian and gay voters. And so the issue almost certainly helped President Obama, and did not hurt President Obama. A lesson that is not lost upon the Republican Party. Now, here are my concluding thoughts. What I've tried to present is a complicated history of the long road toward marriage equality, the beginnings of a complicated answer about backlash, and I think the proper analysis of what's going on politically. But what I want to conclude with, and I'll do more with this in the Law Review article, and this has been neglected by the backlash theorists, is how the courts have indeed advanced marriage equality. And I think there have been three things about what the courts have done, which has been very important in this constitutional litigation. The first, and from my point of view the most important, is the courts have served fantastically important agenda-setting capabilities. Even Bayer and Lewin. Before Bayer and Lewin, the word marriage in our vocabulary only meant different sex. After Bayer and Lewin, linguistically, the notion of same-sex marriage entered our vocabulary, first in quote marks, and now no longer in quote marks. And of course, Goodridge has advanced that a great deal. One of the things that courts have done is that courts are capable of reversing the burden of political inertia, as well as giving publicity to an issue and putting it on the public agenda. And when, as in Massachusetts, the first state, courts have actually recognized marriage equality, even though just for a fraction of the number of people in the country, this is the virtue of federalism, the laboratories of experimentation. And the point of same-sex marriage in Massachusetts, and why Massachusetts is so important in this country, is that this has created conditions for falsifying not only the policy arguments, such as the Bill Clinton argument that he needs to defend marriage as a vulnerable institution against committed lesbian and gay partners raising children. So Massachusetts not only falsifies that this is going to hurt marriage, but it also falsifies stereotypes and even prejudices. And the deepest prejudice against gay people in this country, in my lifetime, in human history, is the prejudice/stereotype that gay people are anti-family. Gay people are selfish, their sexuality is sterile, that homosexuality itself is intrinsically anti-family. And one of the things that gay marriage has done in Massachusetts, and even civil unions in Vermont, has been to falsify that stereotype and provide a whole choreography living examples of how that's just simply not true. And that leads me to my second point. And that is that contrary to what everybody seems to say, not just Rosenberg, but a lot of the leaders of the lesbian and gay rights movement, like John D'Amelio, no one better than John D'Amelio, the brilliant and famous historian, say, well, it's constricted and cannibalized the homosexual agenda. And I say that's simply false. There's a fabulous article by political scientist Thomas Keck who documents how the pro-gay agenda of sodomy reform and anti-discrimination laws flourished during the same time that we were seeing massive backlash in Bayer and Lewin and less of a backlash in Baker and Goodridge. And I would add this, that indeed it was synergistic. And I'll use my home jurisdiction of the District of Columbia to provide an example. DC in 1981 reformed its consensual sex laws, to make, among many other things, consensual sodomy legal. This was 1981. Congress, within months, the Democratic-controlled House of Representatives, by a vote of 281 to 119, overrode the District of Columbia in this sex reform statute to reimpose criminal penalties on sodomy. When the district in the early 90s created domestic partnership, Congress defunded it. These are all Congresses controlled by the Democrats. And then when marriage equality, of course, comes, Congress is all consumed about protecting marriage against gays and lesbians. But right in the middle of it, and right in the middle of President Clinton's adulterous affair with Monica Lewinsky, the District of Columbia in the mid-90s reformed its sex crime laws again, and again decriminalized sodomy. Not a peep out of the then Republican-controlled Congress. When that law went into effect, I think it went into effect 94, 95, the Republicans assumed full control of Congress. Not even Senator Jesse Helms, not even Senator Trent Lott, two of the most anti-gay senators in American history, even introduced a proposal to override the district's sodomy law repeal. And I think the reason for that, and I know the reason for that, because I've talked to some of the staff people and I've talked to religious leaders in the district, was that religions and other groups felt that the marriage issue was their winning issue, but they didn't want to appear to be uniformly and overwhelmingly anti-gay on all issues. John Finnis, a very distinguished Catholic theologian, said in a Law Review article that very year, he said in 1994, yes, the Catholic Church properly believes that sodomy is a terrible sin. But that doesn't mean that sodomy should be a crime, and we really should focus on other issues like marriage. Richard Posner said the same thing in 1992. And that's exactly the way it worked out. So that when Lawrence came before the U.S. Supreme Court, there were lots of amicus briefs. I did one for the Cato Institute, not one of your usual suspects on the gay rights side. And there were briefs for almost 36 religious groups. Yeah, there was not a peep out of the Church of Jesus Christ for Latter-day Saints, the Roman Catholic Church, the Southern Baptist Convention. All of them sat it out in Lawrence, acquiesced in ultimately a constitutional right to engage in consensual sodomy. And so I would maintain, and I do maintain in the article, that not only did marriage equality actually help deliver the gay rights agenda, was synergistic for the gay rights agenda, it actually altered the agenda of the counter movement in ways that I think were very productive. And then finally, I shall argue that one little good that courts can do, I think this is a minor thing but a good thing, is that courts can and do marginalize outlier perspectives that raise the stakes of politics. In Romer versus Evans, the U.S. Supreme Court, a conservative court filled with right-wing Republicans appointed by Reagan, said in a 6-3 vote that the citizens of Colorado cannot disparage lesbian or gay people and take away normal anti-discrimination protections from them based on animus. And Romer and Evans, I believe, has a pervasive influence on anti-gay campaigns, anti-gay rhetoric, et cetera, et cetera. Now, it itself does not prevent anti-gay policies from being implemented, but it certainly, I believe, has lowered the stakes of the campaign against gay rights. On the other side, I think the Supreme Court has also done something potentially productive just this year in the Tabor-Hosanna case versus EOC, where the Supreme Court recognized under the First Amendment's free exercise clause a ministerial exemption to anti-discrimination laws. Now, this is usually not a favorite of liberal commentators, but one of the things that opinion does is that it sends a very strong message to the opponents of marriage equality that even when marriage equality goes through the courts, when it goes through the legislature, there's almost always an exemption for religious organizations, which I think is useful, because it means that marriage equality is not going to entrench upon the inner sanctum, the most sacred domain of the opponents. And what I think the Supreme Court said unanimously in the Tabor case is that even without legislation, the courts are going to prevent political correctness from affecting the structure, hiring policies, and whatnot of religious organizations. Now, how broad that is, we don't know. But I do think this is one of the ways, one point in favor of what the Supreme Court did, is that it does lower the stakes of the identity politics on the other side and provide some reassurance to religious minorities, traditional family values people. Now, that's all I have to say, except that you should read the Boston University Law Review, and you should graduate from the Boston University School of Law and serve on the First Circuit, where you too can write and join landmark opinions.
Okay, thank you for a fabulously substantive lecture with an awful lot to absorb and ponder. And Bill promised me I could answer the first question. I mean, no, not answer. Ask.
No, I actually told her she could answer the first question too.
ask the first question. And so I want to ask you, you published the case for same-sex marriage in 1996. 1996 is the year of Romer, it's the year of DOMA, and those two things are kind of intertwined with each other now in these cert petitions making their way up before the court concerning the DOMA law. And as you said, the First Circuit provides a solid foundation for Supreme Court ruling invalidating Section 3. Interestingly, the so-called bipartisan legal advisory group, which is actually just 3 Republicans, has argued that the First Circuit invented a totally novel legal standard no one had ever heard of before, which is basically Romer and Lawrence and intensified scrutiny, but they've called it a novel, made-up, never heard of before standard. The Second Circuit decides based on intermediate scrutiny, and so now the court has before it a couple different choices. And the Second Circuit says no federal appellate court has given a persuasive reason in light of the court's precedents for not moving to heightened scrutiny. So these cert petitions are coming before the court very soon for a conference. I'm just curious about what you think the court will do with Romer. Will they read it as this kind of in-between standard that's more intensive than rational but not up to intermediate? And it seems unlikely, but would they say, yes, now we can see that we should move to heightened scrutiny, or will they do something else?
Okay, that's a great question. Let me just say 3 things in response to the question, though you're invited to answer it too, Linda. One is, when you're an intermediate appellate court and not the Supreme Court, your options really are limited. It's somewhat presumptuous of you to say, okay, the sexual orientation is now a strict scrutiny classification, and we think this is what the Supreme Court would do. Well, in all due deference to Judge Jacobs' fine opinion in Windsor, that's the Second Circuit case, it's a move the Supreme Court will make when it's good and ready. Now, then your second question is, well, when will they be good and ready? And I think not the obvious answer, but the answer I'm going to give you is it's going to parallel Loving, which I think is really a great decision. If you've not read Loving versus Virginia, aside from the great title, it is a great opinion. And the Supreme Court had not, before Loving, or McLaughlin, which was the cohabitation case right before Loving, the Supreme Court had never held that race was a suspect classification requiring strict scrutiny. It said bad things about race as a classification, but it never actually laid out the doctrinal framework until McLaughlin and then in Loving, the cohabitation and then the marriage cases. So I think the level of scrutiny is, to be jargony, is endogenous to the substantive issue. In other words, I don't believe they really start off saying, well, in the abstract, what should the level of scrutiny be? Oh, well, we have a test. Let's apply the test. No, I don't think they do that. And they figure out, what in the hell are we going to do with this case? And then what do we want to tell the lower courts about what they need to do next? Now that suggests, and this is my third point, that if the Supreme Court is ready today to sweep away all discriminations on the face against lesbian and gay couples and people, in other words, all of the 50 state laws or the laws that discriminate in terms of marriage or anything else, then it will say strict scrutiny. If they are prepared to do that, they'll do what Judge Jacobs did, okay? Now, I don't think they're prepared to do that. For one thing, I don't know that there are 5 of them who are willing to say that. And one of them I don't think is willing to say it is Ruth Bader Ginsburg. So I'm not even going to tell you Anthony Kennedy. No, Ruth Bader Ginsburg, who thinks that Roe versus Wade was a mistake in the sweeping way that the court wrote it anyway. She would have gone with a more narrow opinion, striking down the antiquated, obsolescent Texas abortion law in 1973. So I don't know that you have Ruth Bader Ginsburg for a broad proposition saying sexual orientation is now strict scrutiny, and then that will presumptively sweep away all marriage discriminations, okay? And so I don't think they'll do that in the DOMA case. So that leaves them the third option, which can be, to use a term of art, called fudging, okay? Now it's jargon, but you don't need a PhD in physics to understand what fudging is. And Romer versus Evans is an example of fudging. Lots of soaring rhetoric, but it's not exactly clear what's valid and invalid after Romer versus Evans. and this is a smart thing for you to do if you are a court and the issue is still an incendiary identity politics issue. So you want to fall somewhere between Scylla and Charybdis. Scylla would be Bowers and Hardwick. So you do not want, and I think the Chief Justice doesn't want this either, Roberts. And certainly Ginsburg doesn't. So that's a pretty broad spectrum between John Roberts and Ruth Bader Ginsburg, okay? That's a broader spectrum between Nino Scalia and Sonia Sotomayor, but that's a broad enough spectrum. And neither Roberts nor Ginsburg wants a Bowers and Hardwick, where the Supreme Court issues a disrespectful opinion that's going to be undermined by subsequent events, and it's going to look like Plessy and Ferguson, or Dred Scott, or Bowers, or whatever. They don't want that. It's not smart for them as individuals. It's not smart for the court to do something like that. So that's Scylla. Charybdis might be Roe versus Wade, where it looks like the Supreme Court is just simply ending discussion on an issue before the country is settled on the issue. Now, in Massachusetts, you may or may not be settled on the issue. You can tell me better than that. I think in Connecticut we are. I think in D.C. we are. But I don't think we are in Mississippi. And a lot of the country is Mississippi and not Massachusetts. One of the points I make in the article, Gerald Rosenberg makes this hysterical point that John Kerry may have lost the presidential election in 2004 because of the marriage issue. Okay, that's one of those nonsense that may have lost. John Kerry may have lost the 2004 election for any number of reasons, including that he's from Massachusetts. Go look at your history books. There's only been one time in American history that Ohio has voted for a Massachusetts-based presidential candidate, and that was Calvin Coolidge, not one of the big winners in the presidential pantheon. So you would actually make a better case that John Kerry lost Ohio because he's from Massachusetts. Just ask Governor Romney, same problem, right? You don't have to be a Democrat to lose Ohio. You just have to be from Massachusetts, okay? So, and even Ohio. So the country, I think, is not quite settled on this issue. I think it would be smart for the court. DOMA, it's Dumb or DOMA, is the title of an article by Andy Koppelman. And it's a very appropriate title, because DOMA is a profoundly stupid statute. And it creates lots of dysfunctions and problems and headaches just to administer. And it was passed in kind of a hysterical fit of pique and wedge politicking in 1996. Now, those are not constitutional arguments. Those of you who are students should be aware. And the problem for Justice Ginsburg and Justice Kennedy is to take that intuition and then somehow doctrinalize it. And that's where Romer comes in, because Romer can be read for almost anything, or almost nothing, depending on what you want to do with it. And that's why I think the Boston University opinion here in the First Circuit is such a good one, is that it's an appellate court decision. It's highly respectful of all the stuff the Supreme Court is interested in. Federalism, Lawrence, Romer, it shrouds itself in all these great Supreme Court decisions. And then says, well, none of them quite addresses what we're talking about, but here's what we're going to do with it, and we're going to say it's not rational basis. We're going to come out of the closet on that. We're actually going to be honest on that. Hey! And then we're going to strike it down because we think that on balance it's not. One thing I would read, the best thing I think that's ever been written by a Supreme Court justice in equal protection law is Justice Thurgood Marshall's dissenting opinion in Rodriguez, the 1973, I believe, or thereabouts, school funding case. And whether you agree or disagree with the ultimate position that Justice Marshall takes, Marshall says, Marshall knew more about the Equal Protection Clause than anybody else in the 20th century. And if he were still alive, I would say more than anybody else in the 21st century, okay? And what he said is the way we apply the Equal Protection Clause is not this tiered business. It's really more a balancing. How important is the right to the people who are being excluded? How important is it to the government to exclude them? And how big a change in policy would it be to strike down the exclusion? And can courts do this? It's really a fine balance. It's a judgment balance. So that's a little bit too long, but it's such a good question. More questions?
We have time for a couple more questions.
Several more questions.
Anybody raise your hand and stand up so they can bring the microphone. Karen, this back here.
Hi, thank you for that. I have a question about your percentages there. To what extent do you think your percentages there, the gradual increase in support for marriage equality, is based on the perception that gay people can be good straight people, like they can get married and have a dog and kid and a white picket fence? And to what extent are you uncomfortable with that? There's a certain domestication of people, right? That's required in that argument, and I was wondering if you were uncomfortable at all with that.
That's a brilliant question. Yeah, to which the answer is yes and yes. A lot of that is the normalization of lesbian and gay couples. And am I comfortable with it? And the answer to that is also yes, but I have to give you a because on that one, okay? And here's part of the reason, is that one of the criticisms, which I think is quite valid, this is not the Rosenberg criticism or the Mike Klarman one, but it's criticism of wonderful people like Nancy Polikoff, Paula Edelbrick, and a number of others, that the same-sex marriage movement has de-radicalized whatever radical and critical potential that LGBT thought might have for mainstream America. By centering it on marriage, it has attracted people who are most like other Americans and therefore leaves other people behind. Now, I think that's a good criticism. I think that it has holes in it, like the Rosenberg thesis, among them being that the beneficiaries of marriage equality, no one has been able to document that it's just people who are like other Americans. A lot of working class gays, the couples who've been joined in either civil union, domestic partnership, or marriage are much more disproportionately racially heterogeneous for gays and lesbians, more working class, people who are transgendered even. A lot of transgendered people want to be married. And here's the other thing that I think is very important. Let me go back to the map, one of my maps. And that is, if your agenda is to make family law more pluralistic, this is another way of thinking about your question. The marriage equality litigation has been a godsend to you. Now, how is that? It has created experimentation that goes beyond marriage. When I was growing up, family law consisted of one thing: marriage. And if you had sex and you weren't married, you were a criminal, and that was all you had. So it was marriage or criminal. By the 1970s and 80s, so about the time your parents were born, it was more heterogeneous. There was a cohabitation regime. We were starting to decriminalize cohabitation and whatnot. And so you could get married, but you could also cohabit. And the law has started to regulate that. Today, in your generation, you now have even greater heterogeneity. You have domestic partnership at the corporate level, the municipal level. You have civil unions laws, domestic partnership laws that are marriage in rights but not in language. And then you have, notice I have Wisconsin, I have Colorado, I have Hawaii. These states, let me take Colorado as a good example. Just a few years ago, Colorado passed a beneficiary statute which vests several dozen off-the-rack rights and responsibilities if you become a beneficiary of one another, and it allows you to edit them. So it's a different kind of support system, not a fidelity requirement. It's easy to enter, it's easy to get out of. So divorce. These are experimentations in new forms of family regulation. And I wrote a whole book on what's being done in Europe. It's what I call equality practice. It's what I call a menu of relationship options. And that's what marriage equality has delivered. Now, that wasn't the open agenda of marriage equality. It's really more of a result of three factors. One is people's demands for recognition of lesbian and gay relationships. Second is intense opposition, which often generates compromises. And the third is entrepreneurial thinkers and social movement leaders say, hey, here's what it might look like. Here's what they've done in France. Here's what they've done in Canada, beyond conjugality, to take Professor Kosman's wonderful terminology, the Canadian scholar. So I'll leave you with that thought. That this is not what this article is about, but I just published an article in the Georgetown Law Journal called Family Law Pluralism, which lays this out in really boring detail. More.
Bill, I want to first say you make me proud as a former law professor of what a law professor can do. And you've done tremendous things for the case of marriage equality. My question actually follows up, though, on your notion of marriage pluralism, and that is taking off from an article called, a book called Untying the Knot, written by Tamara Metz, my former Reed colleague. She says basically, marriage is two things. It's a standard form contract that establishes certain kinds of liberal basic rights, but it's also a sanctification. It's a constituting form, a solemnizing form, and she argues that a liberal state has no business sanctifying relationships, that in effect what we really ought to be doing is disestablishing marriage altogether. Do you see the movement toward marriage equality as moving in the direction of disestablishing marriage, so that 20 years from now when you give this talk you won't even use the word marriage?
That's a good question. The specific answer to your question, at least from my perspective, it totally depends on what you mean by liberal. You know, if you're a libertarian liberal, as the Cato Institute is, they would say yes, it moves exactly in that direction. If you're more of an Amartya Sen liberal, which is the state should create conditions for human flourishing, the answer is not so simple, okay? Now, here's what I'll say more broadly, and that is one of the, I think, easy mistakes of the whole debate is an overinvestment in the effect of lesbian and gay people on marriage and family law generally. Most people who are in relationships between different sexes. They self-identify as heterosexual. There are millions of them. They're wonderful, and they produce a boatload of children, okay? So what goes on in family law is overwhelmingly what goes on in heterosexual relationships. And here's what's going on as I see it. Not an expert on heterosexual relationships, but here's what I think is going on. And that is, it is moving, Colin, in the liberal direction the way you're using the term. And this is the theme of my Georgetown article, that it is moving every decade of my lifetime. Family law, and I think also family practice, has moved away from the strongly normative, sanctifying, sanctimonious relationship that that's created by the state and then regulated by the state in marriage, toward a more contractual approach. And again, the Colorado statute might be an example. Because you can literally opt in and opt out of the various rights and benefits. Each person fills out a form when they enter into this beneficiary relationship in the state of Colorado, at least according to the statute. And that's the direction that we're headed in. The other way you can answer your question, that's the direction that Europe is headed in as well. Away from marriage and toward cohabitation. But cohabitation, I will repeat, is regulated by the state. But it's not as much sanctified by the state. And exactly as you're suggesting, Professor Diver, it's regulated by the state in terms of enforcing contracts and libertarian modes, rather than enforcing some kind of norm that we've traditionally associated with marriage. So that's the way I see that.
Okay, I wish we had all afternoon, but students have to go to class. So thank you, Professor Eskridge.